Hey there, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to describe how it's now easier to settle the estate of someone who lived in Louisiana, had a will, but owned no real estate and had less than $125,000 of assets by using the new small succession affidavit procedural rules. Okay, so using the small succession affidavit, instead of going through a judicial succession, also called a full succession or probate, can offer several benefits, mainly speed, cost, and simplicity. So it's not uncommon for people to die in Louisiana under these circumstances where they had a will, but maybe they owned no real estate because they rented an apartment or lived with a family member or lived in an assisted living facility. And maybe they had one or more bank accounts that totaled maybe $100,000 or so or less. Maybe they had a vehicle and a few shares of stock. Or maybe they had a larger estate, but the bulk of their assets were non-probate assets. You know, they had beneficiaries listed on their IRAs, their life insurance, their annuities, or maybe they owned their real estate in their revocable living trust, and they just simply had another account or another asset that was left out of their trust. So the key point behind this small succession affidavit procedure is to be able to use it when someone dies with a will in Louisiana and they have less than $125,000 and no real estate. Then to use it though, all of the people who would inherit under the will and all of the people who would inherit in the absence of a will must agree to waive the formal probate of the will by signing off on all of these affidavits. So when we use this affidavit, the affidavit must include lots of information, including the date of death of the person who died, their marital status, the names and addresses of the people in the will and the people who would inherit if there was no will, a description of all of the assets and their value. And all of these people must sign an affirmation that they waive any right to challenge the will. So if you do qualify for this small succession affidavit, yeah, you get the affidavit completed, then you present the affidavit to the bank if the person had a bank account there, or the brokerage firm if the person had an investment account, and they'll simply transfer the assets over to the people that are named in the will. So if you do qualify for this small succession affidavit, you probably ought to do it because from a timing expense, the small succession affidavit can be done in a matter of days. The full succession can take months or longer. The court and attorney fees are minimal, and it's just simpler documentation as opposed to the court and attorney involved full Louisiana succession or probate proceeding, which requires numerous court filings and judge involvement. And for what it's worth, the small succession affidavit typically does not become public record where certain aspects of the full succession, such as all of the terms in the will, are public. Okay, so just remember this particular video is about someone dying in Louisiana and they had a will, but they own no real estate, and then the value of their assets was less than $125,000. These new rules enacted, I believe in 2024, can make settling that person's estate much easier. Hope that helps. We'll see you next time.